I just got up, had my cup of coffee. I am working on uploading my Sarah Boone Part 2 video. Before I get started, let me just tell you that I want to apologize for my mic in the last video. The sound is all over the place. I know I had a hot mic. I apologize. Anyway, moving on. So I got up. I'm uploading the video to YouTube. And I'm looking for the links that I got from the clerk of court website, and I found the objection that I mentioned in the video that Sarah filed to some of the digital evidence, and it is handwritten by her. It was filed on the 5th of September. Now, James Owens filed his notice to appear on the 3rd. So I don't know why she is still handwriting motions like she's pro se. But anyway, in the circuit court of the 9th Judicial Circuit in and for Orange County, Florida, state of Florida v. Sarah Boone, motion to object by the defendant to state's digital evidence. Comes now the defendant, Sarah Boone, by way of pro se, respectfully requests from this honorable court that my motion be heard as to my reasons why I am objecting to the state's evidence against me, and to exclude or limit the following particular items attempting to be admitted into my criminal case by the state. Objections are for digital contents specifically and only located on the USB jump drive titled as 2020 CF0026030 Boone Sarah Digital Discovery Compilation, which was submitted to defendant on August 9th, 2024. So why is she filing this in September as pro se when she now has a lawyer? I don't understand. Objections by defendant are as follows. I'm thinking her lawyer, this is probably going to get struck and her lawyer's going to write a new one. I'm so confused. This is the craziest. Oh my God. A. Suitcase videos. 3 items. These files were obtained from my personal cell phone. There are no videos located in this folder on Jump Drive. I don't know why that there are no videos. The way she makes it sound is that they're only audio. There were definitely videos. Like, we've seen the videos. There are videos. So the first one is a photograph. I've not seen the still photograph, but I know there is a still photograph. And I've only seen one of the videos. So the first video, yeah, see, it just says audio. So the first one is 2 minutes and 3 seconds. That's the one that I put in my first Sarah Boone video. And then I put a little bit of it in the second video. I clipped it because I didn't want to play the whole 2 minutes again. And then the second video is 22 seconds. I've not seen that one. But it's the same thing, basically. It's just in between the 2 videos, she went over and she flipped it over. That's basically same thing, just flipped over. What is that, a little a? Yes. Okay. Big A, little a. Lack of authenticity. There is no one to testify that the picture and audio are the same as the scene was at the time the audio was recorded and photograph taken. There is no one to testify that the picture and audio are the same as the scene was at the time the audio was recorded and photograph taken. Yeah, because you were drunk and you don't remember doing it. I don't think that matters. Dying declaration. Sarah, I can't breathe, babe. Yeah, I don't think that matters. The prosecution fails to establish authenticity in any of these three items submitted. Florida Statute Section 90.901, supporting case law, Cooper v. State. B. Potential for unfair prejudice. I believe that the singular reason to utilize this audio is for the state to heavily prejudice the jury against me based on my statements in the audio to George Torres. Honey, that's the whole case. That's what you did. I mean, they can't leave that out. That's what you did. I don't know. What do you guys think? The prosecution's evidence is more prejudiced than probative. Florida Statute Section 90.403, supporting case law. I'm not even going to try to say that name. State v. McLean. C. Violation of Fourth Amendment rights, unlawful search and seizure. This one, no. This one does not fly at all. This audio was obtained by an unlawful search and seizure of my personal cell phone, and the defense moves to exclude under my Fourth Amendment right. She willingly gave up her cell phone. She was like, here, have my phone. I've documented every time he's hit me or punched me or stabbed me. It's on my phone. But she forgot what she had recorded the night before. So she willingly gave up her phone. So there's no unlawful search and seizure. Supporting case law, Map v. Ohio, Wong Sun v. United States. B. Body cams, 4 items. A. Lack of authenticity. All of the body cam videos obtained from uniformed officers on the date of incident are time-stamped and documented incorrectly during the entire case while at the crime scene. I don't know about every body cam, but the very first cop that was on the scene, the main body cam that you see when you watch the video, like on Law and Crime, and like the one on my channel that I put in my video, it says on the body cam that it's like 6:00 at night. It's like 18 whatever in military time. That's 6. And I kept looking at the time, thinking, wait a minute, why does that say it's 6:00 at night? Because that's not when this happened. This is like at 1. So I noticed myself that the time was wrong. I'm not sure that that is enough to get all of the body camera footage thrown out, though. Florida Statute Section 90.901, supporting case law, Cooper v. State. B. Violation of best evidence rule. I've never heard the best evidence rule. I'm going to have to talk to one of my lawyer friends about it. The state fails to provide the best version of this evidence under the best evidence rule. The state has not provided true and accurate video evidence, and the defense moves to exclude these body cam videos. Florida Statute Section 90.952, Supporting case law, McCoy v. State. Violation of Miranda rights. I don't think her Miranda rights were violated. The body cam videos recorded me making statements and providing information prior to me being given any Miranda warning. These are illegal interrogations and a violation of my Fifth Amendment rights and should be excluded under the exclusionary rule. Supporting case law, Miranda v. Arizona, Edwards v. Arizona. Okay, here's the thing about Miranda rights that a lot of people don't understand. You have to be in custody and being interrogated. So, Sarah wasn't in custody yet. They were asking her questions about what happened. She was not in custody yet. At the point in which she was in custody and they were asking her questions, she was Mirandized. At that point, that is when what she says can be used against her. Before that, when the cop is just asking her what happened, that's just for them to find out what happened. So that can't be used against her. But here's the thing. After she went to the police station the next day and they interviewed her then, she was Mirandized. And she said the same things in that interview that she said to the cop the day before. So even if all that body cam footage from the day before gets thrown out, the interview, she said the same things in the interview. Well, actually, she said worse things in the interview because the day before, she denied that George was a big drinker. But in the interview, she said that he drank all the time. So even if the body cam footage does get thrown out, doesn't matter because she said the same stuff in the interview where she was Mirandized. But she didn't have to be Mirandized at that point. C. Defendant's interviews. A. Lack of authenticity. This interrogation video has no timestamp throughout its entirety of 2 hours, 6 minutes, and 3 seconds. Florida Statute Section 90.901, supporting case law, Cooper v. State. B. Violation of best evidence rule. The state fails to provide the best version of this evidence under the best evidence rule. The state has not provided true and accurate video evidence, and the defense moves to exclude this interrogation video. Florida Statute Section 90.952, supporting case law, McCoy v. State. The defendant requests that the due date be extended to submit objections based upon the defendant is unable to utilize her sixth constitutional amendment right to counsel, has never been pro se before, is not an attorney or officer of the legal system, lacks requisite professional competency, expertise in the legal field, is currently incarcerated, has extremely limited and restricted resources to conduct extensive legal research to further support objections, no internet, does not have full-time use and access to laptop, does not have full-time use and access to tablet, does not have access to privacy, temporary for in-depth review of discovery, has limited access to defense team, investigator, to collaborate and complete greater work product. These objections were done as expeditiously as possible based on my current circumstances. The process for a pro se defendant requires much more time, especially while incarcerated, than that of an unrestricted, well-educated, resourceful attorney who is fully capable and has all of the aforementioned availabilities. Also, I reserve my reasonings for my objections for in-court oral arguments. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully moves this honorable court in conclusion to hear my reasons why I am objecting to the state's evidence against me and to exclude or limit the included particular items attempting to be admitted into my criminal case by the state. So, that is her objections. So, I don't know what is going to happen with that. I think that's really weird, though. It's the 10th. This was filed on the 5th, and her attorney filed notice of appearance on the 3rd. Maybe she mailed it before that and it's just now getting filed. I don't know. I don't see anything. There's a list of discovery that Owens got from Dave Cacciatore. Every time I say his name, I want chicken cacciatore. I've not had chicken cacciatore since my mom died, because my mom used to make it. And I don't have her recipe. Notice of intent? Oh, that's the battered spouse syndrome. Notion. Oh, okay. So, notice of unavailability in December. What does that have to do with Sarah Boone? Her trial's in October. Oh, maybe sentencing's going to be in December? He's already calling it a win. We can't do sentencing for Sarah Boone from December 16th to December 20th. I'm going to be out of town, Judge, so we can't sentence her then. He's already taken the win. Okay, that's all I see. That's all I see. There's the trial management for the 26th, and the 7th of October is the trial. So that's everything.